You know, just a couple of minutes ago, I spoke with one of our legal experts, criminal defense attorney George Donnini from Butzel, and talked a little bit about, from the attorney's point of view, where an attorney is at when you're at day two of jury selection, how important timing is, and how important perception is when you're standing in front of the jury.
All right, George, we're in day two of jury selection. So how do attorneys, so the prosecution and defense attorneys, prepare for something like this? And how methodic is it when they go through and they're questioning the jurors?
So look, you want to do some basic things to try to get to know your potential jurors. And so there's going to be a host of basic questions that you might ask just to really get a feel for somebody and how they kind of stand ideologically and things like that. But here, you had the ability to watch a very similar trial, essentially the same trial, and learn lessons. And so what is going on in the courtroom is they're asking some questions that they know for sure will come up during the trial. So things about ownership of guns, storage of guns, mental health issues. These are all things that these jurors are going to be asked to confront and deal with as they make a decision. And so really targeting in on those things for this case is smart.
What about time constraints? I know that we talked about that the judge really wants to make sure that they take advantage of as much time as possible and move things along. But do attorneys have that in the back of their mind, or are they just focused on this one thing, making sure that they're seating a jury that it can be impartial and just looking at the evidence at hand?
Yeah, so look, from my perspective, certainly the court and the judge has an interest in moving things along. But a lawyer who's trying to pick an impartial and fair juror from their perspective really shouldn't be concerned about the time that goes into that. You need to put in the time. And if the judge tries to push you along, you got to push back and you have to say, these are important things. We need to know if this person can actually sit on this jury. And so I expect a little bit of give and take when it comes to that. And I would say to the judge, look, I can't do this quickly. We need to get through this. So time would not be a factor for me.
When you say a little bit of give and take, we've already seen a little, I think, friction between the Oakland County prosecutor and the defense attorney already in some of the questions with the jury. How important is it for attorneys to kind of, I guess, put the best foot forward? They're already revealing some aspects of the case, and you've got the potential jurors here. This is the first, interaction that you have with them as attorneys. From that perspective, what's the importance of that first interaction with potential jurors?
Yeah, so look, you're establishing your relationship with the jurors right out of the gates. Obviously, there's 300 plus that got called or however many for the veneer. You're only going to end up with 15, but those 15 are in there, and so it's really important to establish your essentially a relationship with the jurors that you're going to be with for the entire process of the trial, and it starts in jury selection. And so the questions that you ask are important. I did see one where the defense lawyer asked, can you separate what happened inside the Oxford School with what happened outside? And that's a great question, to tell you the truth. And I know the prosecutor objected to that. And what was important, I think, for the defense lawyer is the judge essentially sided with the defense on that question and said, no, they can ask it. You need to be able to separate your emotion. So when a lawyer gets favorable rulings from the judge, that helps to establish your credibility that you're not trying to ask improper questions. And I thought that was a great question because truly what James Crumbly is being prosecuted for is not what happened in the school per se, it's what happened in the lead up to it. And so it's really what happened outside. So already establishing that theme in the juror questions in voir dire, because that's going to, I'm sure, be a theme throughout the trial.
When you're an attorney in this case, whether the prosecutor or defense, you also have the other line that once you seat a jury, things could start right away. Tell us the process. If they seat a jury later on today, as we saw in Jennifer's case, it could be jury instructions and the next morning and we go. But theoretically, attorneys should be ready to go with their case and opening statements.
Yeah, for sure. So you need to be ready to go because you just don't know how long this will take. Now, if this takes days, and a jury is seated, let's say at 1 o'clock in a couple of days, the judge may say, okay, we'll start first thing in the morning fresh, but you don't have control as the lawyer on either side. It's the judge who's going to control that timing. And so, you can't be flat-footed and not ready to proceed. So, but I'm sure the lawyers, certainly the prosecution has done this already. So, I'm sure their opening statement will be very similar, but yeah, you got to be ready to go.
All right, so no jury yet in James Crumbley's case. It is day 2. We are going to have live updates here on Local 4 Plus and clickondetroit.com throughout the afternoon. So on the hour, I'm going to be here with you. We're going to talk about the latest things that we know. So, of course, you can all see our coverage, too, at clickondetroit.com.